Welcome, and thank you for joining us for our webinar, The Revised Title IX Regulations, What Colleges and Universities Need to Know to Stay Compliant, presented by Quarles. I am Lindsay Davis, a partner in Quarles' Milwaukee office. I assist educational institutions on a full range of legal and regulatory issues, as well as navigating complex litigation. I am also known for my work advising and assisting employers on a broad range of labor and employment issues. I am joined today by my wonderful colleagues, Michelle Lewis and Brenna Wilt, whom you will hear from shortly. We'll begin the presentation as soon as we cover just a few logistical items. First, all comments in today's webinar are off the record and not for publication. All attendees have been placed in listen-only mode, but we do welcome your questions via the Q&A box that's located below the slides in the webinar dashboard. If we don't have time to answer all questions during the webinar, we will follow up over email. Quarles is happy to be able to provide CLE credit in most U.S. jurisdictions for Quarles webinars. As of April 2024, the American Bar Association manages the CLE applications, attendance submission, and certificate of attendance for our external webinars. We have updated procedures for tracking attendance for CLE credit. You must be logged in, participating from your own device, and need to actively watch the entire webinar. Please be on the lookout for pop-up polls with an audio notification that will appear at several random times during the webinar. You must click on the pop-up polls to verify your attendance. Regulators require attendance to be verified, and this procedure meets that requirement. Please take a moment to review the resources box below the video feed, where you will find a copy of today's presentation, a survey link to share your feedback, and a CLE application information. You can access closed captioning during the live webinar by clicking on the CC icon in the lower right-hand corner of the video player. Today's webinar is being recorded, and all registrants will receive the on-demand link within a few days. With that, we will get started. So during our time together today, we're going to cover three broad topics. First, Michelle will cover where we've been. We'll do an overview of the 2020 regulations that we've been operating under now for the last about 4 years or so. Then Brenna will tell us where we're at now. We will talk about and overview the key revisions to the 2024 regulations, what you need to know in order to stay compliant. And we'll wrap up our time today with what's coming and what to do now. I will talk with you about recent court challenges to the revised Title IX regulations, as well as the actionable steps that you should take ahead of the August 1st effective deadline. With that, I'm going to turn it over to Michelle. Michelle?
Thank you, Lindsay. So where we've been, just wanted to quickly provide a very, very high-level overview of Title IX, what it is, and what the state of the regulations are to date. As many of you all may already be aware, Title IX of the Education Amendments Act of 1972 was signed into law more than 50 years ago. The law covers a relatively broad spectrum of sex discrimination in education settings, including equal opportunity in both education and athletic programs, discrimination on the basis of pregnancy and parental status, and sex-based harassment and discrimination. So the Title IX regulations clarify the Department's education interpretation of Title IX and how the law will be implicated. Those of you who are Title IX practitioners who've been in this field for a relatively decent amount of time are very, very much familiar with the various levels of guidance that we've received, most notably by way of frequently asked questions, as well as Dear Colleagues letters, which of course have been incredibly informative and instructive in the administrative procedures and processes for Title IX. But unfortunately, those those documents, although they are informative and incredibly guiding, have not had the force and effect of law. So in 2020, specifically May 6, 2020, the Department of Education under President Trump's administration released legally binding revisions to the Title IX regulations. And if those of you all who were around during that time remember that happened in the height of the COVID pandemic, when institutions were scrambling and trying to figure out all of the intersections of how classes were going to be going, how the workforce was going to be evolving, remote work policies. And in the midst of this, we had roughly about 90 days in which to implement the new 2020 regulations that went into effect on August 14th of 2020. Just a brief overview of some of the more significant changes of the 2020 final rule. It certainly was an incredibly, some would say, very, very drastic shift from the previous, of course, primarily Dear Colleague letters and previously executive orders and frequently asked questions, Q&As that had been published by the Department of Education Office of Civil Rights Division. So the new regulations, for the most part, some of the most sweeping and most impactful changes to those 2020 regulations included limitations on the jurisdictional scope of an institution's Title IX obligations. Many of you all can recall the scope was somewhat narrowed to incidents that only applied to persons in the United States. At the time of filing a formal complaint, the complainant must be participating in or attempting to participate in the education program or activity in which, with which the formal complaint was filed, and university-owned or university-controlled buildings or those controlled by student organizations recognized by a college or university were pretty much the parameters in which a university or college had an obligation to respond to a Title IX related complaint. There was also a broader or higher bar, I should say, for conduct deemed to be hostile environment sexual harassment. Previously, the conduct always had to be severe, pervasive, or objectively offensive under the 2020 regulations, which theoretically we're still under at present. The bar was raised that the conduct must be severe, pervasive, and objectively offensive. There was an introduction to schools having the notion of schools having actual knowledge as a standard for the university or college's response, and also recognition that that information, that actual knowledge, had to come by way of either to the Title IX coordinator or an official with authority to act or redress behaviors on the college campus. We also saw something very, very new, which were mandatory and discretionary dismissals of certain types of Title IX complaints. There were prohibitions against the single investigator model. So for those individuals with relatively limited, those individual Title IX offices with relatively limited personnel activity or personnel resources, I should say, a lot of those individuals served as both the Title IX investigator and or the Title IX hearing officer. Well, under the 2020 regulations, that single investigator model was no longer acceptable. And I'm sure that inarguably many would probably state that one of the most sweeping changes in the 2020 regulations were the mandatory live hearings and the cross-examinations. So in January of 2020, when President Biden took office, one of the first priorities that he announced was that his administration would be taking a closer look at the 2020 Title IX regulations. And some of you all may recall, it was also during that same time frame that President Biden, and this may have been one of the first few executive orders that was signed, Executive Order 13988 on preventing and combating discrimination on the basis of gender identity or sexual orientation. That was signed around about the time that the Biden administration was making an announcement that the Department of Education had just received a directive to undertake a comprehensive review of those 2020 Title IX amendments. So the executive order that President Biden signed during that time actually extended the scope significantly of President Obama's executive order 13672, which was a protection against discrimination on the basis of gender identity in the civil federal workforce, as well as sexual orientation and gender identity discrimination by federal contractors. So then fast forward, July 12th, 2022. The Department of Education published the notice of proposed rulemaking in the Federal Register to amend those 2020 Title IX regulations. The department has received over 240,000 comments on the proposed revisions, and the proposed regulations, for many of you all know, have been kind of sitting in a holding pattern since July 2022. And although it's not reflected on the side, I think it's very helpful to understand while we were waiting on the NPRM, pardon me, there was a time, and it was roughly in April 2023. Many of you all may recall that the Biden administration also published the NPRM to address transgender athletes participating in sports activities consistent with their gender identity. So that was kind of sandwiched in between the publication of the NPRM to overhaul the 2020 Title IX regulations. And I think that's worth mentioning because what we have understood since the NPRM has been published to address transgender athlete participation in sporting activities, we have the Office of Civil Rights, just to say, has received over 30,000 written comments, but to date, that issue or that particular portion of Title IX, we still don't have a lot of, well, we have, I shouldn't say we don't have a lot of guidance. We have publications that have been released by the OCR, but again, those publications don't have the force of law. But to date, we are still waiting to receive the actual overhaul of the Title IX regulations as it relates to transgender athletes in participating in sporting activities. That aside, okay, so back to Title IX on sex discrimination. So we were in July, then February 2024, the Department of Education released or submitted the proposed Title IX regulations to the Office of Information and Regulatory Affairs. The OIRA had a very, very expedited review of those regulations, and a couple of weeks ago, well, probably 3 weeks ago, we actually received the final revised regulations for Title IX. That being said, I will turn it over to my colleague, Brenna Wilk.
Thank you, Michelle. So let's talk about some key takeaways from the revised Title IX regulations, which, as noted on the previous slide, will become effective on August 1st of this year. So the first key takeaway relates to the expanded definitions of sex discrimination and sex-based harassment under the Title IX regs. Title IX sex discrimination now includes discrimination based on sex stereotypes, sex characteristics, sexual orientation, gender identity, and pregnancy or related conditions, which can include childbirth, termination of pregnancy, and lactation. This revised standard for sex discrimination and what it encompasses applies the reasoning of the landmark June 2020 decision by the Supreme Court in Bostock versus Clayton County, which decision made it unlawful for employers to discriminate against LGBTQ workers on the basis of sexual orientation or transgender status. The expanded definition of sex discrimination also really updates the existing protections for individuals who are experiencing pregnancy or a related condition within a college or university's education program or activity. Title IX has actually included some protections for pregnant or students who have pregnancy-related conditions since 1975, which is just about 3 years after Title IX went into effect. But the revised regulations that will be effective in August really update the existing protections. And those are as follows. Students, employees, and applicants must be protected from pregnancy-related discrimination, including with reasonable modifications for students based on pregnancy or related conditions, reasonable break time for lactating employees, and access to a clean private lactation space for students and employees alike. And in addition to that, when a student, a parent of a minor student, or some other authorized legal representative informs a college or university of a student's pregnancy or related condition, which, as we discussed, can include childbirth, termination of pregnancy, etc. When a college or university receives that information, it must provide information to the student or representative about the institution's obligations to prevent discrimination based on pregnancy and ensure equal access to its education program or activities. So the revised regs really clarify the protections for pregnant students, pregnant individuals who are participating in the institution's education programs and activities, and also confirms the scope of sex, applying the reasoning of Bostock versus Clayton County. And the expanded definition of sex-based harassment is equally interesting and notable. So the term sexual harassment was defined under the 2020 regulations, and it has been revised to be referred to as sex-based harassment rather than sexual harassment. And this is a key term change. The definition of sex-based harassment versus sexual harassment retains 3 key aspects of the current regulations, meaning that schools need to recognize first, quid pro quo harassment, second, hostile environment harassment, and third, specific sexual violence offenses like sexual assault, dating violence, etc. However, the definition of hostile environment has been expanded. Under the current regulations, which Michelle talked about a bit, the Title IX sexual harassment is defined as unwelcomed sex-based conduct that is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. Under the revised regulations, however, Title IX sex-based harassment includes unwelcome sex-based conduct that is so severe or pervasive that it results in a limitation or denial of a person's ability to participate in or benefit from the education program or activity. This obviously expands the scope of what could be considered sex-based harassment, and it also mirrors the Title VII definition of sex harassment, hostile work environment harassment rather, as the conduct only needs to be severe or pervasive, not severe and pervasive. So definitely another notable change. The second key takeaway is that the revised regulations contain a really broadened geographic scope. The revised regs now require colleges and universities to address all complaints of sex discrimination occurring under their education programs or activities, including but not limited to the items Michelle previously discussed, which is conduct that occurs in a building owned or controlled by a student organization officially recognized by the college or university, for example, a fraternity or a sorority house, conduct that is subject to the college's or university's disciplinary authority, and this is the notable one, conduct that creates sex-based hostile environment within an education program or activity, even if some of the conduct occurred outside of the college or university's education program or activity, or outside of the United States. The 2020 regulations do not extend to conduct that occurs outside of the US. And that jurisdictional limitation has created a lot of confusion for colleges, especially those who have study abroad programs, international trips for students, and things of the like. Isn't that right, Michelle?
Yes, absolutely, Brenna. You bring up a really, really important point. I know several colleges and universities that have, as you stated, international student trips, study abroad programs. Actually, some colleges even have international campuses. So certainly it's going to significantly, for some colleges, impact the resources needed to address the Title IX matters that fall outside of the United States.
Absolutely. All right, thanks, Michelle. Let's move on to our third key takeaway, which is that under the revised regulations, there are different requirements for reporters. The definition of a complainant, as it's currently stated in the 2020, the current regulations, has been expanded, including to allow former students to file Title IX complaints. And this really opens the door to those who have chosen to leave a college or university as a result of sex discrimination or for other reasons. Whereas previously those individuals would have very limited options in pursuing any type of resolution under the university's Title IX policies. That now has changed, and it really opens the door to those individuals who perhaps could have been overlooked by the previous regulations. Starting August 1st, Title IX complaints may also be made either orally or in writing with no signature or formal complaint required, which again were two of the strict requirements under the current regulations that went into effect in 2020. So previously, in order to seek any type of resolution for a Title IX concern that someone may have raised, the individual would have had to file a formal Title IX complaint, included a physical signature, and that would really kickstart the process to resolve that concern. But that now is completely changed. People who have concerns relating to sex discrimination or sex-based harassment can now simply, call the Title IX coordinator, and that will start the process for resolution. And in the same spirit of different requirements for reporters under the revised Title IX regulations, there is some much needed, and very welcomed clarification on the circumstance in which a Title IX coordinator becomes aware of potential sex discrimination or potential sex-based harassment, and the person who raises those concerns does not want to file any type of complaint or pursue any type of formal resolution. Previously, there was really, really limited guidance on what a Title IX coordinator could do in this situation. But now there has been baked into these revised regulations 8 specific factors that guide a Title IX coordinator in making sure they're acting appropriately when a concern is raised, but the individual who raised the concerns isn't super motivated to go through a formal resolution process. So the following 8 factors should guide a Title IX coordinator in determining whether alleged conduct presents an imminent and serious threat to the health or safety of a complainant or other person, or prevents the recipient from ensuring equal access based on sex to its education, program, or activity, such that the Title IX coordinator may initiate a complaint. The first factor, as you'll see, is whether the complainant's request not to proceed, or whether the complainant requests not to proceed with initiation of a formal complaint. So we need to assess whether or not, what the complainant's desires are in that regard. That's the first factor. The second is the complainant's reasonable safety concerns regarding the initiation of a complaint. The third is the risk that additional acts of sex discrimination would occur if a complaint is not initiated. The fourth is the severity of the alleged sexual discrimination, including whether it would require the removal of a respondent from campus or the imposition of another type of disciplinary sanction to end the discrimination and prevent its recurrence. The fifth factor is the age and relationship of the parties. For example, is the complainant a student and the respondent an employee? That's something that we need to consider in determining whether or not a Title IX coordinator should initiate a complaint, perhaps over the wish of the complainant. The sixth factor is the scope of the alleged sex discrimination, including information suggesting a pattern, ongoing sex discrimination, or sex discrimination alleged to have impacted multiple individuals. The seventh is the availability of evidence, which, as we all know, can certainly vary quite a bit from situation to situation. And the eighth and final factor is whether the recipient could end the alleged sex discrimination and prevent its recurrence without initiating its grievance procedures. So again, very welcome guidance to Title IX coordinators who didn't have much to go off of previously under the current regulations when determining what steps to take when they learn of potential sex discrimination, sex-based harassment, and don't necessarily have the full cooperation of the person who reported it.
Brenna, you're so right. Yeah, you're so right that this comes as very welcome guidance, because I know you and I have over the years been on several calls with college and university clients trying to navigate whether and when they step into the shoes of a complainant, essentially. So I think this is absolutely a helpful development for colleges and universities. It also means, in my opinion, that colleges and universities have to be much more diligent about conducting this analysis and making sure that they are documenting, that they are considering each of these factors and how they're concluding whether or not there is an imminent and serious threat that requires the college to step in, even if an individual complainant may not wish to proceed with a formal investigation. So my advice to colleges and universities is, when you're getting complaints and you have a complainant who, for whatever reason, doesn't want to be an active participant in the formal investigation process, you still make sure you're looking at these factors, documenting how you're analyzing them and what your ultimate outcome is, so that if push comes to shove, you're in a position to demonstrate why you did or did not conclude that there was an imminent and serious threat. I think those situations that will often require a college or university to step in and file a complaint will be, as Brenna mentioned, the situations in which we become aware of patterns of sex discrimination, or particularly severe sexual misconduct, violent sexual misconduct, use of a weapon, those sorts of situations that indicate potential threat to the broader campus community. So I think this is really helpful that this is baked into the regulations now, and we know with a great deal more definitiveness what should we actually be thinking about when those situations come up. So thanks, Brenna.
Absolutely. Thank you, Lindsay. All right, let's move on to the fourth key takeaway, which is when to respond to sex discrimination. This is a notable change from the current regs to the revised regs that we wanted to cover today. So under the current Title IX regulations, which went into effect in 2020, colleges and universities must respond when they have actual knowledge of sex discrimination, and only in a manner that is not deliberately indifferent. This standard is really reflective of the changes that Michelle kind of overviewed during her slides, which was to create a very rigid set of standards for colleges and universities to follow. And the standards were arguably more protective of respondents than complainants. And I think that you can see that reflected in this standard of what triggers a college or university's obligation to respond to sex discrimination. Under the revised regulations, colleges and universities must respond to sex harassment and sex discrimination when they have knowledge of conduct that reasonably may constitute sex discrimination. You can see that that is a little bit more inclusive of a standard, and it goes along with the overall themes of these revised regulations, which is to encourage more information sharing. There's a lot more flexibility under the regulations that will go into effect in August. And so this is definitely a notable standard that we'll want to keep in mind as we're all revising our policies and preparing for the implementation deadline. In addition to this revised standard, the Title IX coordinator must monitor the college and university's education programs and activities for barriers to reporting information that could be deemed sex discrimination. And those individuals must also take steps reasonably calculated to address any reporting barriers. So again, we're seeing in these revised regulations that there's really an emphasis on information sharing. Knowledge is power, and schools have more of an obligation to keep their ear to the ground and make sure that no complaints or potential concerns relating to sex-based harassment or sex discrimination are kind of falling by the wayside. And consistent with this, when to respond to sex discrimination, the revised regulations also expand employee reporting obligations. Instead of designating which employees must inform Title IX coordinators of conduct that could potentially violate Title IX, under the revised regs, any employee except those deemed as, quote, confidential employees, like you'll see in the slide, must notify the Title IX coordinator of potential sex discrimination and sex-based harassment. And the revised regs amend the definition of confidential employees, i.e. those who are not required to funnel information to the Title IX coordinator, and identifies three groups of confidential employees. The first is employees whose communications are privileged or confidential under federal or state law. The second is employees whom the college or university has designated as confidential for the purpose of providing services to the individuals related to sex discrimination. And then the third category is employees who are conducting an institutional review board approved human subjects research study designed to gather information about sex discrimination, but only while they are conducting the study. So again, we're kind of flipping the standard here. The only individuals who are not required to share information with the Title IX office are these three groups of confidential employees. And instead, these employees must provide information to anyone who informs them of conduct that reasonably may constitute sex discrimination or sex-based harassment, about their statuses as confidential employees for purposes of Title IX, how to contact the Title IX coordinator, and how to make a complaint, along with how the Title IX coordinator could help those individuals. And another really interesting change under the new regulations relating to responding to sex discrimination and sex-based harassment is a new provision requiring colleges and universities to protect and prohibit peer retaliation by other students. And Michelle has some thoughts on that.
Yeah, Brenna, I do. I think this is, I think it's worth emphasizing this particular provision that's been placed in the new regulations, because we're basically now saying anyone who has participated in any way in the Title IX process, whether it's as a complainant, as a respondent, or even as a witness, may make a retaliation complaint if they believe that the institution or any other person, including another complainant or respondent or witness, took adverse action against them because they participated in the Title IX grievance procedures, or for purposes of adverse action for the purposes of interfering with their Title IX rights. So on a very, very specific level, the new regulations state that when an institution has information about conduct that, and there's that new standard again, reasonably may constitute retaliation under Title IX, it must respond promptly and effectively. So one of the things that colleges and universities are going to have to grapple with is, what does that response look like, right? So while there's no, the preamble doesn't, I didn't read anything in the preamble that stated that there was an expectation that a school actually conduct an investigation and into an allegation of peer retaliation. However, that reasonably may standard of conduct means that schools must take action to address misconduct in order to preserve an educational environment free from sex discrimination. The analysis of whether a specific course of conduct or an act, a single act, is going to constitute retaliation under the final regulations is going to be incredibly fact specific, is going to be determinative on a case by case basis, because there's several overlays and intersections there, right? We also have to take into advisement the First Amendment considerations that may be at issue. You know, I know a lot of schools, colleges and universities have amnesty policies that ensure students will not be disciplined for that collateral conduct related to an incident of sex-based harassment. It's worth taking a second look at our amnesty policies. Do those policies need to be broadened, for instance, to ensure that there is that the institution at large is not inadvertently retaliating against an individual for participating or for not or for refusing to participate in the process. Other considerations we're going to have to address are social media posts, which are ubiquitous, and sometimes we know where those posts, who those posts are coming from. Sometimes we don't know who those posts are coming from. Maybe they're even coming from individuals outside of your institution, outside of the scope, the jurisdictional scope of your Title IX reach. I think often about, sometimes we have campus activities such as Take Back the Night programs, or or other types of activities where students are attempting to raise awareness of sexual assaults on college campuses. Could some of those activities, could some of that speech be classified or deemed to be peer retaliation, right? I know several colleges and universities also, from time to time, individuals will go on to change.org, and they will elicit petitions to have individuals, to maybe out individuals or to have individuals expelled from the university. All of these things are going to be part and parcel for the new expansion, in terms of things we need to think about when we're thinking about the new expansion of the retaliation provisions, or the prevention of retaliation within the context of these new Title IX regulations. So, Brenna?
Thanks, Michelle. Great points, great insights. All right, let's move on to the fifth key takeaway, which is that live hearings are no longer required. And the first couple points on this slide really go back to some high-level comments that have been made thus far in this presentation, which is that a key overarching theme of the revised regulations is to ensure flexibility for colleges and universities to implement Title IX policies and practices that are appropriate for their institutions, regardless of size, regardless of resources. So, these revised regs really aim to enable all institutions to meet their Title IX obligations while providing appropriate discretion and flexibility. The revised regulations also reflect a framework that accounts for differences in the age, maturity, needs, and independence of students in various educational settings. So in that spirit, the revised regulations no longer require a live court-like Title IX hearing as part of the formal Title IX grievance processes, but a live hearing is permitted. Colleges and universities must have a process that enables a decision maker to assess a party's or witness's credibility when the credibility is in dispute and relevant. So if a school opts not to have a Title IX hearing as a part of its Title IX formal resolution processes, the credibility assessment can be conducted in a couple different ways. The first way is questioning by the investigator or decision maker during individual meetings with the party or witness. And then the second way is if a school opts to maintain the live hearing requirement, questioning by the decision maker during a live hearing. So there's still mechanisms for credibility to be assessed. The major change is that the only mechanism available for credibility assessment under the previous Title IX regulations, the current ones, was this live hearing. Now schools will have an option moving forward on how to assess credibility.
And Brenna, I think this is one of the best illustrations of how when it comes to Title IX regulations and the revisions to them, it really is a pendulum swinging back and forth. So when we compare this change to what colleges and universities have been operating under for the last 4 years, you really see that, right? The 2020 regulations were much more procedural, focused, and rigid in their approach, right? You had to have that signed formal complaint. You had to have this live hearing element. What we see now is the pendulum swinging back in the opposite direction. And as you said, affording colleges and universities some more flexibility to make decisions about the procedures they'll use to investigate and make decisions about Title IX complaints, taking into account the resources that they have available to them. So when we get to the next segment of our presentation and talking about what's next, you'll see that one of the important things to do is going to be to sit down with your team and talk about what's going to work best for us based on the size of our team, the resources we have available, the makeup of our student population, et cetera. And I know you'll get to a couple more changes that just further reflect this concept of increased flexibility in the approach that colleges and universities can take.
Absolutely. Thank you, Lindsay. So another very notable change, especially for smaller colleges and universities with less resources than large state schools, is that colleges and universities may once again employ a single investigator model, provided it is clear in their policies when this model will be utilized. Colleges and universities can choose to use solely the single investigator model, or they can choose to use this model only in some, but in not all cases, so long as it's clear in their policies when the single investigator model will be used and when it won't be used. And there's some additional requirements relating to due process and credibility assessment, which relate to what we just spoke about. All right. The seventh key takeaway is that under the revised regs, there are more options for informal resolutions. Under the current regulations, which went into effect in 2020, colleges and universities could offer this only after a formal complaint was filed and not when an employee was alleged to have engaged in sexual harassment or sex discrimination against a student. Now, under the revised regulations, effective August 1st, colleges and universities may offer informal resolution even if a formal Title IX complaint has not been filed. And similarly, informal resolution may be offered for complaints involving allegations of that an employee engaged in sex-based harassment of a student, unless the process would conflict with another applicable federal, state, or local law. And this, again, emphasizes the flexibility of the approach under the revised regulations. I think it also accounts for a complainant's different preferences. Not every complainant has the same preferences as it relates to resolving a Title IX concern. And I think this revision accounts for public comments voicing that. Not every complainant feels comfortable enough participating in a live Title IX hearing and perhaps would like to resolve concerns in a less formal way. So that's definitely a notable change. And for schools that have not previously offered informal resolution, now's the time, as Lindsay will talk about in her slides, to really tease out an informal resolution policy. The second to last key takeaway is that there is more of a permissive dismissal standard under the revised regulations and less of an emphasis on mandatory dismissal. Instead, under the revised regulations, colleges and universities may, but are not required to dismiss a Title IX complaint when, one, the college or university is unable to identify the respondent, two, the respondent is not participating in the college or university's education program or activity and is not employed by the college or university, three, the complainant voluntarily withdraws all of the allegations, the Title IX coordinator declines to initiate a complaint using the factors we previously discussed, and the college or university determines that without the complainant's withdrawal, the remaining allegations would not constitute Title IX sex discrimination, or four, alleged conduct, even if proven, would not constitute Title IX sex discrimination. So, whereas under the previous regulations, there were certain things that needed to result in a mandatory dismissal, these are guidelines for colleges and universities in determining whether they might opt to dismiss a complaint. And the final key takeaway is that under the revised regulations, there is specified record-keeping requirements. The current regs specify that Title IX records must be maintained for 7 years, but they don't specify exactly which records are the ones that must be maintained. But that has changed in the revised regulations, which confirm that the following records are those that should be maintained: complaints, informal or formal grievance procedures and resulting outcomes, notice of sex discrimination and remedial actions, and training materials. And with that, I will turn it over to Lindsay.
Thank you, Brenna. So plenty of changes that we all need to navigate through and make decisions for colleges and universities about where to go from here. Before we talk about a game plan, I wanted to give you sort of one key update in the litigation space, and that is consistent with what I think has become a trend anytime we're getting new regulations or governmental guidance on how to interpret a statute. Within about 2 or so weeks of 3 weeks, I guess it is, of the new regulations coming out, we are already seeing multiple legal challenges to them. So as of May 9th, suits had been filed in 5 different federal district courts across 4 different federal circuits by a number of different states, right? So you'll see that 4 states banded together and brought a suit in the Western District of Louisiana. Another 4 states banded together and brought a suit in the Northern District of Alabama. Texas filed a suit in one of its federal district courts. I think it's 6 different states banded together to bring a suit in the Eastern District of Kentucky, and 6 different states also filed a suit in the Eastern District of Missouri. Now, what are these lawsuits about, and what issues have the parties identified in pursuing these legal challenges? These sort of run the gamut. So the claims include that the new regulations go beyond the statutory language by redefining sex to include gender identity and sexual orientation, that they violate certain requirements under the APA, that they run afoul of the spending clause, that they unlawfully exercise legislative power under Article 1 of the U.S. Constitution. It sort of boils down to, did the regulatory bodies act within the scopes and powers available to them in revising and publishing these regulations? Now, sometimes our advice to clients when there's this sort of level of legal challenge to regulations or other guidance or laws might be to pause and let's see how this litigation unfolds before making any drastic changes. In this case, that would not be our advice, and that's for a variety of reasons. The biggest is, of course, that making the changes that are necessary to ensure continued compliance with the regulations will take some time. And we, of course, are not oblivious to the fact that for college and universities, often there is a pretty complex process that you have to go through in order to make changes to your policies and procedures and ensure appropriate training on those changes. And so to make sure that you're not falling behind, we do recommend that you kind of proceed with what we're calling a four-pronged approach to ensure continued compliance. At the same time, we and you should continue to monitor the progress of those court challenges and see if they do result in any changes to applicable timelines or ratcheting back of regulations that have been included in this latest round of revisions. So with respect to the four-pronged approach, you'll see laid out on the slide what we're recommending our clients do. Number one is you're gonna want to assemble your Title IX team. Number two, you'll need to revise your policies, procedures, and related communications. Number three, you're going to need to ensure proper training. And number four, you're going to need to update your campus community. Let's quickly break down each of those four steps. So step one, assemble your Title IX team. As Brenna made clear during her presentation, right, the new regulations allow for this flexible approach in some situations. And that means that there is sort of a fork in the road as it relates to some of the decisions that you'll have to make and reflect in your policies. Do you want a single investigator model? Do you want a live hearing? Do you want to allow for increased option for informal resolution? You need to bring your team together and talk about what approaches will best serve your campus under these new flexible Title IX requirements. In doing so, I think it's helpful to consider what have been the major strengths and challenges under the current process. So when you look at the last 4 or so years, what has been working really well versus what has been a major challenge in those circumstances where you've had to do a live hearing? Did you have the resources you needed? Were you able to find a hearing officer? Did that process seem to serve the respondent and complainant and other parties involved well or not so well? So you'll want to bring your team together. You'll want to look at what resources you have available, what's the size and level of experience of your team, and what's been working and not working. And that'll allow you to collectively make those fork in the road decisions, right? Do we want to go left or right here in those instances where an option is now available to you? Having undertaken those discussions, the next step is going to be to revise your policies, procedures, and related documents. Now, based on what Brenna shared with us earlier today, we know that minimally the revisions to your policies are going to need to include updating key definitions, right? What counts as sex discrimination and sex-based harassment, for example, under our Title IX policy. You're going to need to update your jurisdictional statement because no doubt right now, your jurisdictional statement reflects what's required under the current regulations, not this expanded approach, which now brings in more international conduct and conduct that's maybe occurring off campus. You'll want to update your reporting requirements, right? So now we know a complainant can include somebody who's no longer with your college or university, so you need to ensure that your policies reflect that. Then you'll have to clarify which approach are we going to take? Are we going back to single investigator model? If so, is that for all cases or some cases, right? Make sure you're clearly defining the parameters around that. Clarify whether you're going to continue to use the live hearing approach. Make sure you're specifying and expanding upon available pregnancy-related accommodations and updating your non-retaliation statement to ensure that it includes peer retaliation. Bear in mind that your policies and procedures have to be, currently at least as it stands, they need to be updated and implemented by the August 1st, 2024 effective date. And that means that, if you have multiple layers that you have to go through in order to get policy changes approved and published, you'll really want to be working on this sooner rather than later. We do recommend that you take advantage of the resources that are available, including those that have been made available by the Department of Education. And I do think it's appropriate to work with your legal counsel to ensure that the policy and procedure updates you're contemplating will bring you into compliance with the current, the upcoming requirements under the Title IX regulations. Okay. That brings us to step 3 under our 4-pronged approach, and that is to ensure proper training. Under the revised regulations, all employees have to be trained on the obligation to address sex discrimination, the scope of conduct that constitutes Title IX sex discrimination, including those new definitions of sex-based harassment, and the applicable notification and information requirements, right? So when does an employee have an obligation to report something to the Title IX coordinator? When do they have an obligation to share reporting information, to share the process with the individual who has brought the concerns to their attention? Your Title IX personnel also need to be trained on supportive measures, investigation procedures, informal resolution and decision-making procedures, really your grievance procedure, and how to serve in their Title IX personnel capacity in an impartial manner. Title IX coordinators also need to be trained on their specific responsibilities, record-keeping systems, and other training necessary to coordinate Title IX compliance. And all of these trainings have to occur when someone's hired, when they move into a role where training is required, and on an annual basis. The last step we recommend is making sure you have processes in place to update your campus community, right? Make sure that your community understands where they can find your new Title IX policies and procedures. Make sure that your materials that are posted online and shared throughout your campus are updated and available to members of the campus community. One thing that sometimes gets overlooked is if you have sort of postings or communications that you send out during orientation about Title IX policies and procedures, you want to make sure any key updates are reflected in those visual aids and campus communications as well. And then consider whether you want to implement some methods to confirm that members of the campus community understand their reporting requirements and the new complaint procedures, right? Do you do some sort of Q&A presentation? Do you make resources available to students, to faculty, to staff to ensure that they are comfortable with and understand these big and key changes? Okay. With that, we've reached the end of our formal materials. I do believe there are a couple of questions that have come in through the Q&A. Before we get to those, I, of course, want to invite you to feel free to reach out to us directly if there's anything we can help with as you navigate the new and revised regulations. And to remind you that we have a really robust Title IX subgroup here at Quarles who is standing ready to assist you in any way that we can. With that, Brenna, Michelle, are there any questions that have come through the Q&A that we can answer in the next 2 minutes or so?
Thanks, Lindsay. There was a good question that came through that I think would be helpful for us to address. The question is, what if an alleged incident happens on your campus, but the alleged perpetrator does not attend your school? Do you have an obligation to investigate or notify the school that the perpetrator attends? I'm happy to tackle the first part of this question, and then I'm going to turn it over to my very capable colleagues to give their opinions on the second part. As we talked about with the permissive dismissal standards under the revised regs, the fact that the perpetrator or respondent does not participate in your school's education program or activity is a potential basis for dismissal. So considering various factors, that's something that we can do. We could dismiss the complaint in this circumstance, but it's not a mandatory grounds for dismissal. So there's some discretion there.
And I think even if you were going to go the route of dismissal on that basis, Brenna, we of course would want to ensure, and I'm assuming for purposes of this question, that the complainant is someone who attends our campus. And if that is the case, minimally, we want to ensure that we're offering supportive measures to that complainant and resources for them to ensure that an investigation can be conducted if that's what they would like to occur. I think you also have to be thinking about, even if this person is not a student or an employee on our campus, is there that risk of a broader safety concern? And for that, you'd have to know more about what the alleged conduct is, right? But if this was a violent sexual offense, if this was something where we're aware of a potential pattern of conduct, those factors may shift in favor of conducting that investigation yourself on your campus. Michelle, anything you want to add there? She might be muted. I do see that we are right now right at 1 o'clock, and we want to be very respectful of your time and your calendars. So we will wrap up today. To the extent that you submitted a question that we didn't have time to address live, we will be sure to review those questions and follow up by email. We thank you so very much for your time today, and we hope that the content was helpful to you. Have a wonderful